in private session. And yes, protective measures, obviously, as soon as possible. Actually, I think, nonetheless, we'll just briefly go into private session for a moment.
We are back in open session, Madam President.
Thank you very much. A disclosure by the defence of any defences in accordance with Rule 7980, and at the moment I understand there are none. Is that right?
Yes, I've never known how you could have an alibi to a JCE.
No, well. Yes, in the conduct of proceedings, we'll deal with disclosure in respect of cross-examination of witnesses, disclosure which must be made in advance, but I don't think we need to do that. Right. Okay. Trial briefs, I think, was the next. Mr. Nichols, the OTP says it would 2 months before, I think, the start of trial. You say the 30th of September, if it happened to be the 30th of November. Yeah. And yes, the defence. Ms. Haynes, you have the option, although there's something I'm going to add in a moment, but you have the option of a pre-trial brief, as it were, at after the prosecution or before you begin your case, and I rather assume that you want to do it before you begin your case.
Well, whenever I deliver it, it'll say these are not crimes against humanity. You can have it now if you want.
Well, thank you very much. But there is, however, there's an added extra thing that I want to say about ruling that I want to give about this, which won't surprise Mr. Nichols, nor I imagine you, Mr. Haynes, given your jurisdiction. Article 64.3 of the Rome Statute says that the trial chamber shall confer with the parties and adopt such procedures as are necessary to facilitate the fair and expeditious, emphasised conduct of the case. Regulation 54, which deals with status conferences, the first status conference, says that the trial chamber may, in accordance with the statute and the rules, issue any order in the interests of justice for the purposes of the proceedings on, inter alia, the following issues. And two of the issues that are germane to this point are H, the issues that the parties propose to raise during the course of the trial, and P, the defences, if any, to be advanced by the accused. The trial chamber is of the opinion that it would assist the fair and expeditious conduct of this trial, which I referred to in my opening remarks this morning, for the defence to provide a document before the start of trial, which sets out, first, the matters which the prosecution are proposing to lead in evidence with which the defence takes issue. Second, sets out in general terms the nature of your defence, and that means going further than saying these are not crimes against humanity, Mr. Haynes. We do not expect you to provide the complete detail of the defence at that stage. The provision of this document does not preclude you from raising further issues at a later stage if those become evident to you in the course of investigations, nor does it encroach upon your right to file a pretrial brief. And we therefore propose to order you to provide this document 1 month before the start of trial. So is there anything you want to say about that?
No, we'll comply with that, of course.
Thank you very much. Yes. And then I think, unless there's anything... Oh, I'm sorry, Ms. Massidi, yes, as far as the victims are concerned, you may file a brief. I assume it will be before you, if you decide to call any evidence as to the views and concerns of the victims.
Yes, Madam President, our position at the moment, we are still finalizing our internal discussions, but our position will be to file the pre-trial brief before the start of the trial. As it was
yes.
in the Abdallah Rahman case, again, if my recollection is okay this morning, I believe the prosecution filed 1 month after the LRV filed and then the defense filed in the Abdallah Rahman case. We are, of course, open at any order of the chamber. We will comply, no problem at all. Thank you.
That's fine. I honestly can't remember. I rather thought that in the Ar-Rahman case that the defence filed before they started to call their evidence, but I may be wrong.
I think, Your Honour, there was a choice for the opening statements. If there was a choice of doing the opening statements for the LRV as well, at the start of the trial, or once we will request to submit evidence, if ever we will request that. I think this was the option.
Yeah. Well, I'll check. I'll check that over. We're going to have a break before we deliver various oral rulings, and we'll check what that was.
Thank you very much.
Yeah. Pre-trial motions. Yes. The Office of the Prosecutor says 30th of October if the start date is the 30th of November. The defence, effectively going back to the question of the start date, is I'm going to come on to that separately, I think, but a determination of of the accused's fitness to stand trial. Yeah, I mean, do you want to say anything about deadline for the filing of motions?
No, we'll comply with whatever order you make in that regard, Your Honour.
Ms. Massidi, you're the same, are you?
Same as well, Your Honour.
Right, thank you. Okay, well that brings us on to opening statements, which we've more or less had a discussion of it. We'll come back with the hours at that stage. On the question of victims' participation, yes, I think what we'll say there that the defence invites the deadline for applications by the victims to participate 30th of September 2026, and CLRV request until the end of the COI case, or at least until the close of the prosecution's evidence. I think we're going to go, as we did in the Al-Rahman case, say that it's going to be the end of the prosecution's evidence, unless there's any objection to that. Mr. Haynes.
Perhaps a slightly different observation, and that is going back to the point that's still in the air, as it were, as to the parameters of the case as a whole. If this case does involve 49 incidents and 73 deceased, then even allowing for multiple dependents, one would expect the number of participating victims to be in the low hundreds and not the high thousands. And Ms. Gibson and I have had recent experience of the harm that can be done in admitting thousands of victims to participate in proceedings, only for them to find out in the reparations phase that none of them fall within the ambit of the convictions, if any. So I would hope there'd be some careful analysis on the part of those assessing these applications as to whether they fall within the ambit of this indictment as it is currently pleaded, because it's doing victims no favours to allow thousands and thousands of them to believe that they might receive compensation at the end of the day, when that is unlikely even at this stage. The other observation I would make, which comes from my experience in the Bemba case, is that multiple applications throughout the trial process overwhelm the defence, because we have to look at them and nobody else does. And we have to review them at a time when we're cross-examining other witnesses or presenting our own case. And so I would invite you to consider whether or not that, given the potentially relatively low number of victims who do qualify to participate in this case, whether that shouldn't be done before the trial starts.
Right. Well, Ms. Masidi, yes, first of all, and then I think I'll go to the registry.
Thank you, Madam President. Just very briefly, I wanted to recall that at the request of a pretrial chamber, the prosecution indicated that the number of incidents are only indicative of victimizations, and they are not to be considered an exhaustive list of potential victims. This was confirmed by the decision confirming the charges, and therefore I suspect, and these are our assumptions at the moment, that a high number of victims will manifest themselves for trial. And our assessment is done by, of course, having contact with the affected communities. And we can already indicate that a number of victims already enter in contact with us to manifest their willingness to participate in this trial. Second, Your Honor, if the prosecution is going to add new incidents, then at that point in time, victims will need time, in any case, to continue to manifest themselves for trial. So the end of a prosecution case seems to us, as in previous cases, the most reasonable deadline in order to effectively grant the right of victims to participate in this trial. Thank you.
Right. Does the registry have any observations to make on this?
Mr. Dubiston, we are completely in agreement with this position, which is also yours. I could also ask Mr. Ambach to give you extra information if you so require.
Mr. Ambach, yeah.
The only point I would have to add to what the legal representative has already submitted, which is also part of what we submitted in our own filing as to the scope of the case, is that the burden on the defense and the prosecutor in terms of the analysis of applications would be minimal if one were to follow the ABC approach that we have proposed to continue from pre-trial into trial, whereby only the unclear forms would come to the analysis of the parties and the final decision by the chamber, which, as we also submit, would be minimized to the later stages of trial, which was obviously also a part motivating our suggestion that one were to continue the possibility of victims to come forward until the end of the evidence hearing. Thank you.
Right. Well, we certainly approve the ABC approach. I mean, I think that's now standard through all trial chambers. So, really, the submission of the registry and the victims represented, rather, is it should be the end of trial. Defence say cut-off date, and prosecution didn't say anything really, I suppose, on this. All right, it's one of the ones we'll give a ruling on when we've dealt with all other matters. Witness preparation. a lot of this will be dealt with, as I say, in the conduct of proceedings document, which we'll issue as soon as practicable. Yes, the prosecution can have the same witness preparation protocol as it had in Abdul Rahman. There is and the adoption of the protocol is used for preparation, familiarization and vulnerability will apply as well. However, there's one matter I want to mention because of what happened in the Al Rahman trial. The proceedings were delayed one morning because the witness who was due to appear that morning had requested during the 24-hour, if I can put it, quarantine period before they give evidence to speak to the office of the prosecutor because he had remembered something or wanted to change something. And that request was not transmitted until the morning that the witness was due to testify, when he did give new information, and as a result there was a delay. Accordingly, if that is what a witness requests, and it matters not whether it's a defense witness or a prosecution witness or somebody called by the CLRV, then notwithstanding the 24-hour quarantine period, that request should be immediately transmitted to the party calling the witness, and unless there is good reason why they should not speak to the witness, they should be allowed to speak to the witness and obviously make a note and provide it to the non-calling party. But it was a lengthy delay which was unnecessary and in my view need not be repeated. Right. Unless there's anything else on any of that, it's standard. Right, the sitting schedule for trial. Now this does bring me on to the fitness of the accused, Mr. Haynes. As you rightly pointed out, and you filed a motion to that effect, the finding of fitness related to the confirmation proceedings, and the Chamber is obliged to make a separate finding on that issue. And you very sensibly propose that the three gentlemen who examined him for the purposes of the confirmation proceedings should be re-instructed to re-examine him. And we propose to make that order hopefully either today or tomorrow. You also ask that they be made available for questioning. I think we will, the first thing to say, it makes sense because these three experts examined him for the purposes of the confirmation proceedings. Therefore, they don't have to go back over all the background that was taken on the last occasion. As regards having them brought for any questioning by the parties, I rather think we'll wait and see what the reports say before we make such a decision.
I agree, Your Honour.
Thank you very much. In that case, as I say, we'll. I only hope that they can carry out the assessment with some speed. So therefore, at the moment, it's a bit difficult to set a schedule for trial until we've had an up-to-date report. But it seems to be that because of his age and potentially medical problems, there will have to be a day off, and I see the suggestion is that it's in the middle of the week. But as I say, I'm reluctant at this stage, without further reports and without an assessment made by the experts of to set a schedule. So I propose to adjourn that until we find out what the situation is, unless anybody thinks differently. No, I'm taking silence as assent. The representatives of the victims finally want a secure and private remote room. I think you have to take that with the registry. I mean, if they can arrange that, that's fine by the trial chamber. It's not really a matter for us. The final matter was the suggestion by the prosecution of an alternate judge. I don't think that really is necessary. All right. Are there any other matters? We're going to adjourn, and I suppose we could try and do it before, just to go through the rulings we're going to make. Just give me a moment. I'm reminded, Mr. Nichols, I should have asked you, have you got anything to say about the experts examining him?
Well, you've made your decision, so no. We would have, but you've made your decision.
It didn't occur to me that you were going to object, but...
We had something... No, we accept that. The one point I would make very briefly is we would hope that your honors would instruct the experts. We would not agree with the defense's proposed letter of instruction in its entirety.
Yeah, I forgot about that.
Some of the points we feel we would take issue with, but so we think your honors should do the instruction according to the test from Strugar and Hadzich and Bagbo. And so I appreciate the trying to save time and be helpful, but we would not agree with this letter going as is.
Yes, all right. All right. And in fact, quite rightly, of course, the people are going to be concerned with the registry. Is there anything you want to say on that, Mr. Dubuisson?
No,
Mr. Dubuisson. No, I believe that to find experts that are immediately available and who know the interested party, I think that this is the best solution. And today, I do not believe that they will deviate very much from the previous recommendations.
Well, yes, we'll have to see what they say rather than anticipating it. Okay. Yes, Mr. Haynes, all right, so the prosecution doesn't much like your letter, so I think the chambers will write...
We were only trying to be helpful.
Yes, thank you. All right, yes, I'm sorry, I forgot about that. All right, what we're going to do is adjourn until 2 o'clock, just so that we can take time to consider the various matters being raised. Before I do that, however, can I just say one last thing, which really has no bearing or impact on the case or how it will be conducted, but for the purposes of transparency, knowing that there is public interest in this case, I should say, and this is myself speaking rather than on behalf of my fellow judges, it's probably well known that the world and the pool of international criminal law lawyers and judges is a limited one, and it is therefore probable that judges and counsel will have met before this case or during other cases, or possibly at conferences or even social events. In this case, as it so happens, I know counsel on both sides. As far as Mr. Nichols is concerned, apart from the fact that both he and Mr. Jeremy appeared as prosecution counsel in the case of Al-Rahman, Mr. Nichols and I worked together now over 20 years ago as counsel at ICTY. Mr. Haynes and Ms. Gibson, Mr. Haynes I've known, though not in a professional way in the same way as Ms. Nichols, for almost as long, and Ms. Gibson for less time. We have met and, as I say, are likely, almost certainly, to meet again at seminars and social functions. Although it's not possible to predict that with any certainty, the one thing it is possible to say with certainty, there will be no discussion whatsoever of this case between parties and the judges at any such functions. And as I said already, it has no impact on the way that this case will be conducted or any rulings that may be made by this chamber in respect of submissions made by all sides. So thank you very much, and we'll adjourn until 2 o'clock.
All right, we will.
I give the various rulings. One thing I did miss out was really to do with items relating to victims. Firstly, the VPRS and mapping reports. And the question of household forms as opposed to individual ones, as well as victims in pre-trial. Now, we had in mind, and I just want to hear at this stage if there's any objection to make various orders, really for the VPRS to file a report including the possibility of having a mapping report and household forms. The main mapping report to be filed 30 days after the Article 74 judgment. I see Mr. Ambach indicating assent, I think is the polite way of putting it.
Assent.
And next we were going to authorize the use of household forms in addition to individual application forms, unless there's an objection. If there isn't, then we'll authorize it. If there's an objection, we're not going to make a ruling, and you can make submissions from my side.
Thank you, Madam President. As far as we are concerned, we would prefer to maintain the individual. As far as we are concerned, we would prefer to maintain the individual form and the household form, so that victims can choose which one, because on occasion, some victims would like not to complete a household form because some members of their family may not be aware of what happened.
Right.
So we would prefer to maintain both options. Thank you very much.
Right. Well, is there any objection to this? If no, I see Mr. Haynes shaking his head. I see Mr. Nichols shaking his head. Right. Then we will authorize the use of both forms, Ms. Masida. And finally, we were going to order that the victims who participated in the pre-trial proceedings are authorized to continue participating in the trial proceedings. Any objection to that? No. Okay, well then we make that order as well. We didn't mention, but I'm going to mention now this, that pursuant to Regulation 37 of the regulations of the court, we're going to limit parties, participants and registry in their written submissions to 12 pages, which is what we did in Al Rahman. If you, for some reason, want to add to that limit, you must apply for permission and explain why. As far as further submissions are concerned, we're going to hold 2 more status conferences. We would prefer that, unless there is something that needs urgent resolution, submissions are made at those status conferences so that they can, if at all possible, be dealt with orally. But as I say, if there's something really urgent, then of course you can file a submission. Right, it was brought to my attention next, before I deal with the rulings, that I wasn't altogether clear this morning about the question of protocols to be used. So I'm going to now read out what we say about protocols. As a general rule, the Chamber will use the protocols that are already in place in the Chamber's manual. As I've already indicated, Chambers will allow witness preparation. The registry is instructed to file in the record the witness preparation protocol, the familiarization protocols as used in the Al-Rahman case, which mirror those in the model conduct of proceedings. The registry is to liaise with the parties and participants and report back to the Chamber on the proposed use of dual status, vulnerability and redactions by the 15th of June of this year. If changes are foreseeable to the e-court protocol, the registry is to liaise with the parties and report back to the Chamber with a proposal, particularly as regards submission of evidence during the course of the trial by the 15th of June. Right, I hope that yes, sorry, and I forgot to say that the cut-off, no, I was about to say that actually, but anyhow, the cut-off date for any applications from the victims to participate in the proceedings is the end of the prosecution's presentation of evidence, and we will follow the ABC participation approach. Right. As far as the fitness, the assessment of the fitness of the accused to stand trial, what we decided to do is that in the light of the short discussion, it would be preferable if the parties could liaise together and prepare a proposed joint letter of instruction. We were going to do it ourselves, but then we thought that you might then want to object, so it's probably simpler if the two of you can come to an agreement. We would like that, please, by Friday of next week, which is the... actually, no, I think we said a week today. What's a week today? 3rd of June. Yeah.
Wednesday.
Yeah, sorry, my fault. Not Friday. Wednesday, the 3rd of June. And registry, we would be grateful, please, if you could contact the experts immediately to check on their availability and let us know by the end of the week. That's the 3 experts who saw him before. Right, as regards, first of all, then to the decisions we've come to, the start of trial, we are prepared to accede to the prosecution's application of the 30th of November as the start of trial. The trial will run on a daily basis until the judicial recess, or thereabouts. We have to wait for the report on the accused's fitness, and they will specifically be asked to, if they find him fit to stand trial, about the proposed sitting. The Chamber would obviously like to sit, subject to witness problems, 5 days a week. But we note the recommendations that were made for the confirmation hearing, and so it may well be that we'll have to adjust it. If we have to have a day for the accused not to be in court each week, that doesn't necessarily mean it won't be a sitting day, because we can use that day to deal with any administrative matters or any legal arguments that are due to take place, subject, of course, to the accused waiving his right to be present. So effectively, at the moment, as I say, subject to what reports we get, it should be taken by all parties, participants in the registry, that we will be sitting continuously until the recess at Christmas. We very much also urge the registry to make the necessary arrangements so that for the opening statements at the end of November there can be interpretation, even if there isn't a sufficient pool of interpreters for witnesses. I think it's important that opening statements can be understood by those in the Philippines. Right. So the deadlines for the prosecution in the lead-up to trial. The prosecution provisional list of witnesses and evidence by the 29th of June. Its trial brief, final list of witnesses, and list of evidence to be relied upon in the trial, 31st of August, which is 3 months before the trial. And the same deadline, that is the 31st of August, applies if you wish to add new incidents. Plus the list of experts, and appreciating the difficulty sometimes in getting experts to provide reports. We would like as many reports as are available, and if a report isn't available, then at least a summary of what it is expected that the expert will be saying in his report. Any evidence disclosed or to be added to the list of evidence after that date is strongly discouraged and will be subject to the Chamber's authorization, good cause to be shown, with a full explanation for the reason for the delay. Simply a reminder that disclosure of exculpatory evidence and Rule 77 should be done on a rolling basis. After our discussion this morning, review your evidence to make sure that we avoid having repetitive, irrelevant, or over voluminous evidence. And as already discussed, the witnesses interviewed under Rule 55, the schedules that we discussed and which are familiar to you from the Al-Rahman case. As far as pretrial motions are concerned, if there is any issue that needs resolution before the start of the proceedings, pursuant to Rule 134, 1 and 2, again, cut-off date 31st of August. I'll give you the dates of the status conferences in a moment, but we will deal with them all, I hope, then. And of course, obviously, if it's urgent, that's a different matter, and it should be filed as soon as possible. The dates for the next status conferences between now and the summer recess are the 23rd of June and the 14th of July. As indicated this morning, the defence's indication of issues and defense to be provided by the 30th of October. The legal representative of the victims' trial brief, 28th of September. As far as agreed facts are concerned, we're not going to set a deadline, but we will review the position at each of these status conferences. We echo or repeat our hope that you can reach a substantial number of agreed facts. Having considered Ms. Maceda's representations, the LRV can receive notification of what facts have been agreed and can make submissions on this, which the Chamber will consider. As far as the conduct of proceedings is concerned, I've mentioned some matters. There will be other matters dealt with in that. Effectively, it will be it's intended that it will very much be the same model as that in the Al Rahman case, which also models the Model 1 in the Chamber's manual. But if anybody wants to suggest amendments to it, they must do so by Friday, the 5th of June, so in other words, next Friday. I mentioned this morning that we were thinking of trying to find a balance between the submission and admission process. But I'm reminded I think that the conduct of proceedings and indeed the Chamber's manual states that where there are documents which the Chamber or the parties consider are important ones, it can be, whether or not it will be admitted, can be dealt with at the time that the document is tendered. But I really do emphasize we don't expect to be drowned in documents. So those are the rulings, unless anybody thinks I've missed anything out that I said I'd give a ruling on. And unless there are any other matters, that concludes to the status conference. Nobody got any other matters? No, right. Yes, thank you all very much.
All right, we will agree.